All right, well, my clock says 1:30, so we'll get started on time here. Welcome, everybody. My name is Eric Hauge, and I'm the Executive Director of Homeline, and you are joining us today, Wednesday, January 12th at 1:30 for another one of Homeline's webinars. We started these back in April of 2020, and now it's 2022. And we are still going at it. And today we have a number of guest speakers on, and we're going to be going through an overview of some of the tenant landlord state legislative policy proposals that have been at the legislature this past year and into the 2022 session. And we have with us authors of some of that legislation, both Minnesota State Senator Kari Dziedzic and Minnesota State Representative Kaohly Vang Her. In just a bit, we're going to get a chance to hear from them about these proposals and kind of the overview of what's going to happen at the legislature with these bills during the 2022 session. Before we get to that, just a few logistical things. And as always, we're going to have Rachel Sterling, who is Homeline's COVID-19 eviction response coordinator and housing attorney, just do a brief overview of the current legal situation with tenant landlord law and the eviction phase out, because we get a lot of questions about that. Every time we hold one of these sessions, that was what was the original purpose of these sessions. And so we'll cover some of that. And we will leave time at the end for Q&A, both with the legislators and Rachel will field some questions as well. We did get a number of questions in advance, so we'll cover those first, but we ask that if you do have questions for the legislators or for or any legal questions, submit them via the Q&A system on Zoom. It's easier to track that rather than the chat. So just a reminder about what Homeline is. We're a statewide nonprofit organization. We serve the entire state and provide free legal organizing, education, and advocacy services for renters. We have staff that speak English, Spanish, Somali, and Hmong languages, and interacting with renters throughout the state. And we currently have a staff of 26 advocates, housing attorneys, organizers, and others. There's our contact information. There's direct language lines. If you are a renter and you have a legal question, you can ask it on this webinar, but we really only provide general legal information. And if you need advice about your individual situation, please call our free and confidential legal hotline. Again, we have information on our website about the eviction moratorium phase out and the current situation. And we're keeping those updated. We'll be updating some of that with some recent news just this week that Rachel will cover in just a moment. And then we also have a schedule of our upcoming webinars on our website coming up and recordings of previous ones. So the next one we have scheduled is on February 2nd, and we will be having on housing attorneys from Housing Justice Center, Max Tsai and Shana Tomenez, who are going to be covering their work as Rent Help MN field partners, kind of talking through the experience of how to navigate as a tenant or an advocate, the Rent Help MN application process. So that is on Wednesday, the 2nd of February, and we'll be scheduling future webinars after that on a number of other topics, including an analysis of eviction filings and numbers throughout the state during the phase out. Just a reminder, Rent Help MN is still open and receiving applications. That's the main protection that renters have against eviction for non-payment of rent. So we strongly encourage renters and our clients to go apply. We know that there's a number of other local programs, including this one, which is specific to St. Paul and Ramsey County. Again, Rent Help MN is statewide. This program is specific to renters in Ramsey County. And I'll put information about all this in the chat once Rachel gets started. So with that, I'll hand it over to Rachel.
Thanks so much, Eric. And I am Rachel Sterling. I am the COVID-19 eviction response coordinator and a housing attorney here with Homeline. So the really quick, I won't keep you long from the juicy part of this presentation, but basically the big question is what's happening with evictions right now. So beginning back in October of 2021, basically most of the restrictions that were in place on landlords on what evictions or notices to vacate or non-renewals went away. Those restrictions expired. So there is still one exception in place. Basically, as Eric alluded to earlier, if a tenant has a pending rent help MN application or with any of the emergency COVID assistance programs, I think rent help is really the one that's kind of still the most prominent. Some of the tribal lands also got, the tribal entities, excuse me, got some funding, as well as some of the local counties and such. But rent help is kind of a great one-stop shop for all of that. So if a tenant is behind on rent and they have a pending application, a landlord cannot file an eviction for non-payment of rent while that application is pending. That protection lasts through the end of May. This year it expires on June 1st of 2022. Something that tenants should keep in mind is that if they can access the info, they need to provide their landlord and or the court with the proof of the pending application. And if they happen to know the reason, if there is any delay, what the reason for the delay is. That's all part of the temporary session law that was passed last year. So that can include things like your confirmation letter. If you're a tenant, I know that Rent Help puts out that information. There may be other ways to go about that as well. But something to keep in mind that's exceptionally important. We've been seeing folks who maybe have a pending rent help application, but their landlord isn't aware of it for some reason. Even if so, the tenants think that the courts know that they've got pending applications, but it's just not true. That the court won't know unless you tell them. So it's really, really, really important that if an eviction is filed, no matter what the reason, regardless if you have defenses or protections in place, it's really important to show up to the initial court hearing. Most of those are going to be over Zoom in some sort of virtual capacity across the state. Most of the courts are still doing that. But again, if there is a court hearing, it's really important that the tenant shows up so that they can tell the court that they have that pending application. If they don't, an eviction is almost certain to occur because the court is going to find the tenant to be in default. And so that's just a whole mess that can be avoided by showing up and showing that you've got this pending application. As always, you should seek legal advice about your situation before the court hearing. We are a great resource for that across the state, but there are other legal options, private attorneys, legal aid if you qualify, that sort of thing. Moving on to the next slide. One of the things that was part of the phase out was a pre-eviction notice requirement. That was one of the things that was that requirement went away back in October. However, some cities have made their own pre-filing eviction notice requirements. Specifically, St. Louis Park has a 7-day requirement for non-payment evictions, and Minneapolis has a 14-day non-payment or 14-day pre-eviction notice requirement for non-payment evictions. So if you are a landlord in that city, then you need to give some sort of notice if you're evicting a tenant before you can go file that eviction. There are also a couple of federal regulations for that require pre-filing eviction notices. It's going to be specific to certain types of properties. We've talked about the CARES Act almost ad nauseum, it feels like, regarding this is a lingering protection or requirement in place from the CARES Act that CARES Act covered properties, which are the ones that are covered under VAWA. There are several resources available to determine whether the property you're in is a CARES Act covered property or not. It's got to do with federally backed mortgages, if the property is covered under Violence Against Women's Act, a couple of different ways to go about finding that, which Eric will post in the chat. But the other one is new. It's specifically for HUD properties. And what this one requires, it's a little bit different than the CARES Act, is that for, it's still a 30-day pre-filing notice that landlords have to give to those HUD covered properties. But this HUD notice has to also include any local rental assistance that might be available to tenants as part of that notice. The HUD property one only applies during emergency situations. So COVID is one of those. They call that out. So this is in effect right now, went into effect in November. And so that is one of the other kind of federal requirements that have come into play. So basically, long story short, check, you very well may have some sort of pre-eviction notice requirement that you have to make if you're a landlord per one of these regulations. So it's good to double check with with an attorney. And then finally, my last slide, recent updates. 2 points that we want to make sure people are aware of. First off, Rent Help MN recently, very recently, as of last week, let us know that starting this week, as in 2 days ago, they are now restricting future rent applications for 1 month instead of the 3 months they were initially granting. So you still have to be behind on rent in order to apply for Rent Help MN, but previously you were able to then, as part of your application, ask for an additional 3 months of future rent. And now they're restricting that to, you still have to be behind on rent, and now you can only apply for 1 month of future rent. And it's the 1 month based off of when you're applying. This is not retroactive. It is applications that are received as of Monday the 10th going forward, has this 1 month instead of the 3 months. And then there are, we just got notice that there are several cities who have enacted mask mandates across the metro area. So Minneapolis, Hopkins, and Golden Valley specifically call out rental properties as being part of this mask mandate. And so that means that anyone who's in a common area, tenants, anyone, property maintenance workers, that sort of thing, common areas, and if an employee, a landlord or employee is coming into a tenant's residence, they should be masked up as under this mandate or under these requirements. So again, that's Minneapolis. That went into effect last week on the 6th, and then Hopkins and Golden Valley just passed theirs yesterday, actually. And so Golden Valley is going into effect tomorrow, and Hopkins is going into effect on the 14th at 12:01 a.m. So we can link to the specifics of those as well, but those do impact rental properties. And I think that is my real quick overview of what is going on in the phase out.
The quick overview again. If you have questions about any of these, put them in the Q&A. We will get to questions for the legislators and any legal questions regarding the phase out or other related issues at the end of the session. And so with that, without further ado, I'll pass it over to Homeline's Public Policy Director, Michael Dahl.
Hello, everyone, and thank you for listening in on this call and offering questions to myself and our legislators, who are just some great folk working with us on affordable on tenant protections. Just a little bit of an introduction to myself. I've been working on homelessness, tenant protections, and affordable housing issues for about 30 years now. And 7 of those years working for Homeline specifically on tenant protections. With us today, we have 2 leaders who in the campaign to improve tenant landlord law. Senator Dziedzic and Representative Her are both authoring bills to increase tenant rights and protections. So the Senator and Representative, I'm wondering if you'd like to introduce anything about yourself, include your interest specifically on tenant protections and housing issues more broadly. But if you want to share something that's a bit more personal, go ahead and do that. I always tell folks I'm an heirloom gardener and I love dark chocolate, so please send it my way. With that, I'll turn it over to Senator Dziedzic. Can you introduce yourself?
Hi, thank you, Michael. Hi, everybody. Thanks for being here today. As you said, my name is Kari Dziedzic, and I have the honor and privilege to represent the Senate District 60, which is mostly the east side of Minneapolis. I have both the West Bank and East Bank campus of the University of Minnesota, Augsburg campus, Cedar Riverside, and the northern part of Seward. So it's a very diverse community. We have a lot of great ethnic food over here. We have a lot of award-winning restaurants and chefs. And so it's just a great place. You can basically eat your way around the world in this Senate district. So that's what I enjoy. I got involved in working in housing issues, having worked with Hennepin County and doing a lot over in North Minneapolis, where you had a lot of poor or low income people, and some of the issues they were dealing with their landlords were, one in specific that really got me involved in this was she was having sewer backups in the basement. And she was afraid to call anybody because she knew she couldn't afford to live anyplace else. And she didn't want to be kicked out. And she knew that they were going to shut that down. And so she actually went to the neighborhood group that I was working with and talked to them about it. And they contacted me. And so we found her housing first, and then I called the city and said, look, we're finding her housing. Don't condemn the place. We know you're going to condemn it, but we need to get her housing first because, what is she going to do? She had young kids. But it was not safe to live in that house with the sewer. I mean, the sewer backup was actually flooding the basement. So it was pretty bad. She had called the landlord. This had been going on for a while. And so doing a lot with problem properties in Minneapolis and dealing with those landlords and how do you, get the landlords, and there's a lot of good landlords. I always say that, but I was dealing with a lot of the bad landlords that were not paying their property taxes. They were not, taking care of their tenants, and their properties were just a problem. They were not only taking care of their tenants, they weren't taking care of the property. And so that, how do we fix that and how do we get that? Because I think everybody should have the right to have, live with dignity. And that includes and starts with having housing. So thank you.
Thank you, Senator Dziedzic. Representative Her, that brings us to you.
Thank you, Michael. And thank you all for being here today. So I represent a district in St. Paul, just across the river from Senator Dziedzic, and I'm in 64A. And the issue of housing is really important to me. I think I've told Michael probably the story about 100 times, but housing is near and dear to me as an immigrant to this country. My parents were able to buy their first home within their first year of coming to America. And when I think about what that meant for our family, having housing security, and there were times where my family relied on public assistance, that we relied on going to food shelves and to pantries and to be able to get clothes from churches and shelters, that we always were housing secure. And that when you have that kind of housing security, the ability for your children to study, the ability for you to maintain your health, the ability for you to have a job and hold a job, and all of the ways in which we see why disparities exist within our communities, I feel like housing is at the center of that. And I think about how our family was able to break the cycle of poverty within that one generation, in that all of my siblings are educated, and we had the privilege of going to college because we could focus on our studies, and we did have places where we could study. And we were all able to become secure in jobs and in our professions. And so I, for me, fight really hard for this, because everything about what we do with housing, whether it is housing affordability, whether it is tenant protection, whether it is just all aspects and spectrums of it, homelessness and the unsheltered, all of these pieces of it, I think that is very critical for us to look at. And they are all pieces in which would address other disparities that exist within our lives. And so this is why this issue really matters to me. And as I watch my community, mostly are still renters, and I see the disproportionate impact on those who are low income and who are renting, and what that means to them, and why tenant protection is so critical. If we're ever going to move society forward and ensure that everybody gets to be productive in a way that means and that is valuable to them, then this is what we really have to focus on. So I really feel passionate about this, and I really appreciate that I get to do this work with Senator Dziedzic and with Homeline.
Thank you both, Senator Dziedzic and Representative Her, for that background too. I think it really helps us ground ourselves in why this work is important and why you do so as well. Now, again, I want to point out that I want to keep things conversational. Representative Senator Dziedzic, if you want to interject anything at any point, go ahead and do so. That said, periodically, I will ask if you have any thoughts about some of the bills that I'm working through on here. And it'll be your chance to both tell us what you see as far as a conversation at the legislature regarding these issues, but also as a call to action to the almost 190 attendees who have signed up for this webinar to let us know what we can do to help get these bills passed into law. So now let's get into the meat of things. By way of context, I want to point out that as has already been said by Senator Dziedzic, most tenants and landlords get along and they're great folks. Sometimes people have disputes, but most of those disputes don't require court actions. Tenants and landlords often work things out by themselves. But while this number is still too high, it is worth noting that there are roughly 15,000 residential evictions filed in a normal non-pandemic year, which is less than 3% of Minnesota rentals that we're talking about. So tenants and landlords work through most issues together, but sometimes where we see some situations where legal questions arise. And so one thing I want to point out is that Minnesota law needs to change at times because times change. Tenant landlord law needs to remain fluid. What was the case in the 1970s or 1980s when most of the current tenant landlord statutes were enacted came out before the internet existed. So the previous laws aren't always sufficient. Some tenant landlord statutes are much older than that. For example, the framework for our eviction rules were written before Minnesota was even a state. So definitely need to keep that in mind as we're pushing for changes. What's happening, because the state is not playing a leadership role, is that as Rachel pointed out, there's cases where cities are stepping up and passing their own ordinances to provide more protections for tenants. But what that does create is a hodgepodge of local ordinances, which are doing what really should be a state responsibility, which is providing a guide for consistent tenant-landlord relationships. I also want to point out that in many cases, Minnesota tenants right now have fewer rights than are afforded to those in other states. This last point of context I want to note is that landlords write the leases. As such, and as expected, landlords want to make sure that they protect their interests. We need state law to better protect renters, to sort of even the playing field that is right now just seems a little, well, more than a little unbalanced. So today we're going to talk about 8 pieces of legislative proposals that would protect tenants more. And I'm just going to briefly talk about, just sort of go through what they will be, and then I'll get into the details of each with the senator and representative. First, we're asking for a 14-day pre-eviction notice before a landlord can take a renter to court for non-payment of rent. Second, we want to make a few eviction expungement reforms. We want to prohibit non-optional fees for non-optional services. Fourth, we're going to talk about a privacy statute clarification and strengthening. Fifth, we'll talk about breaking your lease in case of infirmity. We'll talk about a statewide heat code and expanding emergency repairs, as well as reducing court filing fees. I want to note that for the first 2 issues, the 14-day pre-eviction notice and the eviction expungement reform, it's on Homes for All's legislative agenda, and the rest of the issues are actually endorsed by Homes for All and on their endorsed agenda. I should note I'm a policy co-chair for Homes for All as well. Before we get into the details, I just again want to ask Representative Her and Senator Dziedzic, do you have any thoughts on a macro level about these issues and how they're seen in your caucus or in the legislature more generally?
I can go first if that's okay, Senator Dziedzic. She probably has her own thoughts about where we are in the Senate, but in the House, though, I want to assure everyone that housing remains a top priority for us. I think many of you saw that Chair Hausman will be retiring, but the committee itself is super committed to this work. We actually have, prior to session starting, I think in December it was already that Representative Hausman came to all of us and said, what are the bills that you want to continue to move forward? And all of the bills that are listed on this slide here, Chair Hausman is actually extremely behind and supportive of, and so we will be putting all of our tenant protection bills forward again. And we also know that in the House we fight really hard to say that we already allocate so little to housing and to our homelessness issue, our unsheltered issue, and so we continue to fight not just for getting these bills through, but getting more money allocated to the budget for housing, and that's very important to us.
In the Senate, it's a little different. I will say the Senate DFL caucus is extremely committed to getting this legislation through. We are concerned about housing and understand that housing is a core to everything we do. During the pandemic, you kind of saw how important it was. In the beginning, they asked people to stay home. But how do you stay home if you don't have a home? And so that just shows how important it is and how core it is to what you do every day. The Senate Republican caucus, and I'm not a member of that, so I'm not speaking for them, but they have a different, they kind of have a different viewpoint. I know there are some over there that truly believe we need to reduce the disparity rate in the home ownership gap. They are concerned that we don't put enough money into housing. But then, when push comes to shove, the money wasn't there in the budget last year. So we're going to be working hard to really push some of these issues. We have a positive budget balance. I don't see a surplus because all of it is not in the bank. And I've been through this enough that, the forecast can change between November and February. So I don't want to get ahead of myself. But I think we have a lot of opportunity right now, historic opportunity to do a lot of good stuff with one-time money. And I think housing is a great use of that because it is one-time money, but we can put one-time money into helping, build more housing, find ways to get more people of color into home ownership, and to deal with our unsheltered people. And so we just have that whole wide range of housing issues that we have to deal with, including tenant protections. And I think we can use this opportunity to do that.
All right, thank you very much for that context. Now we're going to get into the meat of the legislation. And again, Senator Dziedzic, Representative Her, if you have things as we're going along, go ahead and interject them. But I do have breaks where I ask some questions, a question of you about sort of the impression of things. First on our agenda is the pre-eviction notice. It says that evictions, I just want to know right now that evictions can be filed very quickly and sometimes without a tenant's knowledge. In fact, the landlord can file an eviction for non-payment of rent the day after rent is due. Minnesota is one of only 4 states that does not require a landlord to formally notify a tenant before an eviction action for non-payment of rent. For our solution to each of these issues, I'm going to be relying heavily on what's on the slides because I want to make sure that you get the details. So with pre-eviction notice, the notice would require that there be a 14-day formal eviction, that there be notice given for 14 days before a formal eviction action can be brought into court. This would allow tenants to fix the problem, to negotiate an agreement with their landlord, to point out the landlord perhaps had an error in their records, or to quit the lease and vacate the property without making and filing an eviction necessary. What would be in that notice is information about how tenants can seek help to apply for emergency financial assistance that helps them and helps the landlord at the same time. And hopefully we'd be avoiding court costs, we'd be saving time and money. The courts are less busy, landlords that get paid if the issue is resolved, and tenants would not have this mark that appears on their records in perpetuity unless there's action taken. I want to have people think back to moving on to the second issue here about eviction expungement reform. I want to ask those of us who are listening in who are homeowners to think back on when you last rented. Remember that there used to be a time when landlords did reference checks. Well, then came tenant screening agencies, and then came the internet. Screening on a whole host of matters is now commonplace, and renters carry their history with them to every landlord they rent from, no matter how long the bad records apply for. Many criteria have a disproportionate impact on Black, Indigenous, and households of color. The simple filing of an eviction action by a landlord appears immediately on a tenant's record before the court has even rendered a judgment or even heard the case. Once an eviction files, it appears on a tenant's record as an eviction indefinitely and is not reported and is reportable by tenant screening agencies for the next 7 years. But it also sits in court documents that are publicly accessible in perpetuity. An eviction is often a permanent bar from safe, secure, and decent affordable housing for the folks that we're talking about, and it contributes to homelessness and very unstable situations. So under our proposal, we would say that there would be a prohibition of having something appear on someone's record unless a court judgment has been rendered in favor of the landlord. The court would order an expungement if the tenant prevailed in the case. If there was a case was dismissed, let's say a landlord did not show up at a hearing, the parties agreed to an expungement, or there's been a request by a tenant because they've settled part of the case with the landlord that was brought up. And also that eviction of over 3 years ago or longer would be expunged from their record. The court would also consider expungement if there's been a change in a defendant's circumstances, indicating that an eviction case is not a reasonable predictor of someone's future housing situation. So someone temporarily lost a job or lost a roommate and needed to have more income coming in, and that eventually got fixed. The court could say that the expungement should be the eviction should be expunged because it is not a predictor of future behavior. Senator Dziedzic, Representative Her, Homeline sees these two issues, pre-eviction notice and eviction expungement reform, as game-changing issues and really help balance the landlord-tenant interests. Wondering if you have any quick thoughts on this issue, on these two issues that I bring up. And if not, that's okay too.
Well, I can go first here. I think that I think they're both important. I think they are not just for a fairness issue, which they are, but also to help people, again, find legal help and get the aid they need to pay the bills. So I think that is important to have that notice because of that. I think it also is helpful. Somebody asked, and maybe one of the questions will come up later, but they asked, what's the impact of the cities doing it? And when the cities do it, it kind of creates, it's not consistent across the state, but it might create that pressure. We had that with smoking bans a few years ago, where there were smoking bans put in place by different cities, and that eventually led to pressure to have the whole state do it. So I think it was 2010, 2011, when a lot of the cities and counties were deciding to ban smoking in bars. And it was controversial at the time, and but it helped push the state to get to that same conclusion. So this might help, as they find that in cities, it's not the problem that everybody thinks it could be, and that it actually is working to move the process through quickly. I think that would be helpful. As far as expungements, we had this discussion in the conference committee a few years ago, where I had it with some of my Senate colleagues, where if you get a forfeiture, that comes off your record after a certain amount of time. So why shouldn't this expungement come off your record in a certain amount of time? We just think it's a fairness thing that, for a homeowner, they, lose a job, and most of forfeitures are losing your job or a medical issue, and that might be the same with tenants. And so we think it's a fairness issue. If you have one come off, the other one should come off, and especially on these expungements where they were settled, but they were never removed from the record. That's just really not fair. So hopefully we can get some common sense movement on this year.
And I'll just add really quick, and I agree with you, Michael, that this is a game changer. And I guess when I think of game changer, I think of it as not even like that like it's this huge thing we're doing. We're literally putting the same standards on landlords as we are on tenants, and that when we think about right now landlords they must wait. I'm sorry, required of tenants, and that there are wait times that landlords have, and we have such a much higher requirement on tenants, and so I think that. It's just common sense that if we want the pendulum to actually stay closer to the middle, we should give everybody the same standards to work with. And I think for me, one of the most important pieces of these provisions is the education piece, giving people access to the resources that they need. I know that when I speak to people within my community, they just think that this is the way the systems work. They don't even know what alternatives are, what additional resources they have, what recourse they have. I mean, just the ability to, in the pre-eviction notice required and and what we're expecting landlords to include in some of that information is really, really critical. And when you are somebody with no social or cultural capital, you have no idea where to even go. You don't even know what questions to ask. You don't know what to ask, what you don't know about. And so I think to me, those are really, really important pieces. It's not just saying we need to change these standards, but we need to give people the proper resources that they need. And I really appreciate that about these particular bills.
Thank you. Next, we're going to go to an issue that I see simply as a matter of business transparency. And I'm not speaking about all landlords right now, but Homeline, in our calls, we're noticing that many landlords are increasingly relying on mandatory fees built into their leases. So instead of simply raising the rent to cover their costs, they're tacking on fees. Many of these fees are not being disclosed until the lease is revealed well into the process, and oftentimes after someone has already put down an application fee of $20 to $50 per adult. These types of fees are tenants required to pay, have these vague sounding names like administrative fee or lease processing fee. We also have fees that are charged to use a certain bank and a portal used to, essentially people paying money to pay rent to the bank for the landlord and not disclosed before seeing the lease. And then we've brought this up for the last few years. There's a very large landlord that actually uses something that they used to call the January fee. And tenants owe it, it's $100. Why? Well, because it's January and it's in the contract. These fees allow landlords to draw into potential tenants with the deceptive rent amount and effectively raise the rent with required fees in the lease that are often, again, revealed long after the application process as the application process has already begun. So what we propose is that there be non-refundable fees for non-optional services would be prohibited to ensure that tenants don't face unaffordable concealed charges after signing a lease. Administrative costs, we think, should be incorporated into the rent so that tenants understand how much they'll pay each month before they enter into a lease. Again, I'll ask both of you if you have a sense of how you view this issue. And again, don't feel the need to comment on everything, but this is definitely one that I think we ought to be able to get some traction on.
I would just say, Michael, I think that this bill to me, it's so common sense that I don't think that there is any other industry that we are a part of or any product or services we buy that somebody gets to tell us later on, oh, by the way, you have to pay this too. And so I think that, we should get what it is we think we are purchasing. And so this to me is really important for that piece of it. It's just ensuring that people understand what it is they're getting into. And again, I always think of this from my low income, community lens in that, somebody may think $100, is not a big deal. But for people from communities that look more like me, that $100 is going to be like if they're going to have groceries for the next few weeks. And so it matters, and it is important. And knowing how much people already spend on, rent and the proportion it takes up of their income, these fees really add up. And it is going to be a matter of whether somebody chooses to buy medicine for themselves or if they have to pay some of these fees for these months. And so I think it's really important.
This is, to me, just a basic consumer protection bill, because that's what it does. It is like Representative Her said, there is no other place, or maybe it was Mr. Dahl that said, there is no other place where you sign up for something and then after the fact you get, oh, and here's this fee and here's this fee and here's this fee. I think that there have been other places that tried to do that in the past, and we've clamped down on them and said, no, this doesn't work. And so this is just a basic consumer protection bill that should pass. So we'll keep working on it.
I was talking with Representative Ryer yesterday, and she said it's kind of like someone ordering a Coke and then being charged 10 cents for the glass that it's being put in. It just doesn't really make sense. And thought that analogy, we don't want to be comedians here, but that was a little bit of comic relief, I think, to how I was thinking about the issue. Next, we come to privacy violations into a tenant's home, and they can range from an annoyance, like a landlord not providing ample notice that they're going to enter, but it can also be very intrusive and unsafe abuses. For example, our hotline has heard from clients whose landlords have walked in while someone is in the shower or asleep. Minnesota privacy law on tenant landlord issues, the language is outdated and vague. Well, it may sound, many people assume that landlord requires a 24-hour notice to enter an apartment. Actually, Minnesota law just says that reasonable notice be provided. And that's a really subjective and squishy. Can people still hear me? I had something come up on my laptop.
We can hear you a little. Yeah, it's all right.
Hello, can people still hear me? Okay.
Yes.
Okay. Thanks a lot there. I had something scary pop up there. It's also important to note that the current law has a $100 penalty if that is really inconsequential compared to the cost of filing for this penalty to be enforced. It's $100. We would actually switch it up to being up to 1 month's rent plus attorney fees, so that some of these really serious and egregious invasions of privacy could be dealt with. Homeline's proposal basically says this, that reasonable notice means 24 hours. That a landlord would also only be able to enter the unit between 8 a.m. and 8 p.m. and have a 4-hour window of time. Now, that said, if a tenant wants to grant access earlier and outside of that time frame, it's completely their right to do so. A tenant has the right to waive that 24-hour notice if it's important enough for them. But if tenants' rights are violated, they would be able to sue for a meaningful penalty. Again, I'll ask, are there any quick thoughts on this after each piece of legislation? I just want to get your sense of thing, if you have any sense of thing, if you want to add to it. And I can move on to the next one. We'll probably have questions along the way that help address the situation. Okay. Next up, Minnesota does not allow a tenant to break a lease due to a medical condition. The Fair Housing Act does not explicitly give tenants this right, which is why a growing number of states, 8 thus far, have enacted their own laws protecting some of the most vulnerable citizens. Minnesotans should be able to put Minnesota should put the following statement explicitly in its state statutes, basically saying that if our proposal is that if a physician-certified medical condition, illness, or disability hinders someone's ability to maintain their current housing situation, they would be able to end their lease with a 2 months notice. If they're moving into a medically approved, assisted, or accessible unit. This is a reasonable notice, and it mirrors the law for an estate when a tenant has deceased. Tenant would have have to document that they are actually moving into the specific housing that the doctor has prescribed. Again, it seems like something where we wouldn't want someone choosing between their health and their housing situation between these two issues. They really shouldn't be competing values. And I'll ask once again, Representative Her, Senator Dziedzic, do you have any comments on this, or should I move on?
I've actually heard from a lot of constituents on this. I've had a few constituents that have had traumatic brain injuries that had to move out of their apartment. And again, this one is just another common sense bill. So she had literally just signed a lease and then got, hit by a car and needed to go into not just rehab, but more of an assisted living situation. And she couldn't afford to pay both rents. And so that became a problem. I think in 2020, right before COVID, I was close to getting Senator Limmer to hear this bill because he was starting to understand this impacts everybody. This could happen to anybody, and this could be, people's lives can change in a minute. And when they do, this is something that, people are going to have to look at. And especially as people get older and our parents get older with dementia and stuff like that, you just never know when somebody's going to have to move. And so hopefully we were this close to getting the hearing, and then COVID interrupted everything. So we're going to just go back to keep pushing it.
I just want to point out, and Representative Her, this is thanks for carrying this bill. It actually got through in the House 2 different committees with bipartisan, actually unanimous support. With the Housing and the Civil Law committees. So the House is communicating with resounding yes. Let's make this happen, and we need to just get it to cross the finish line in the Senate. Or at least get it through with the negotiations. Representative Her, anything to add to that, or is that basically covered?
No, that's good. And I guess, Michael, can I just maybe address a question I saw in the chat that somebody asked, why should it be the landlord's responsibility to educate people? I just wanted to share my opinion on this. And the truth is like, sure, none of us have any responsibility to anybody for anything. But the truth is that I feel like when the balance of power lies within the person who creates the contract and the person who gets to decide if you stay or if you go, like if where you are is no longer an option, why shouldn't they be responsible for giving people alternatives? When you go to the doctor and the doctor tells you a treatment is no longer working for you, we expect that doctor is going to give us, well, what are the other options that are available to us? They're the ones who control the information and have an understanding of the industry and how it works. That we would think it was unacceptable if a doctor told us, well, this treatment is no longer an option for you, that you wouldn't have the ability. They wouldn't tell you then what your other options are or where you could possibly go for assistance. But teacher says that I can't teach your child anymore. We don't expect that. We say we expect that teacher in that school to provide us with other options. I don't understand why then in this particular situation, it would not be the landlord's responsibility to educate people. And I think in every industry where people are, they do provide options. They don't really have to either, but they also understand that if they are the person holding the information and having the power in this balance between tenant and landlords, that it should probably be their responsibility to do this. And so I think it's just, and as human beings, I think that this is what we do when we care about people, and that our objective is not just to make money on the particular unit, but that if there's legitimate reason why people shouldn't be in a certain space, or that you have to evict somebody, or that there are, for all of these bills that that they do provide alternatives to people and provide them with the education and the information necessary. So that's what I want to make put out there, because I just think, well, if we all just take the position that it's nobody's responsibility ever to do that, it's not required in education or healthcare for people to provide you alternatives, but they do, and that's because we care about other people as human beings who we are part of society with. I know maybe it's a little bit of a harsh response, but I just feel like at some point we all do need to take responsibility in knowing that when people don't know something, we should help them. We should be a part of the solution.
Thank you. Okay, and we'll move on to the next issue. And actually take 2 issues together here. The statewide heat code and emergency repairs are both in the same bill. Both of you are in this legislation. And so these are basic habitability things. The statewide heat code and emergency repairs are both habitability issues. Homeline, for instance, on the heat code receives hundreds of calls from each year from people who lack or have inadequate heating, which can have serious health consequences, particularly for children and for seniors. Currently, I like this word a lot, hodgepodge. There's a hodgepodge of city adopted minimum heat codes. It's been the case for a very long time that rental properties across the state, many have required that heat be provided to 68 degrees. And I believe that's, Worthington, St. Paul, Minneapolis, most use 68 degrees as a sort of a standard that are passed through city ordinances. But there are also cities and towns that rely on something on the building code. And the building code doesn't actually require that you provide the heat to the tenant, but simply that your equipment be capable of doing so. And so we think because of this sort of variation, that some cities and towns don't have a heat code or a building code whatsoever. Others have the building code that they rely on, and then others have city ordinances that if someone moves from one community to another, they basically are, sorry, I just received a note. One city to another, they may not know what their protections are. And so what we would ask is that a statewide heat code be enforceable by city rental inspectors where city rental inspectors were applicable, and that individual tenants provide their own private court actions. If the tenant does not control the heat then we would say that between October 1st and April 30th, heating would be maintained for a minimum of 68 degrees Fahrenheit. Other habitability issues that we see are dealing with emergency issues that unfortunately aren't classified yet as emergencies under state law. Right now, emergencies are restricted to these issues: running water, loss of hot water, loss of heat, loss of electricity, loss of sanitary facilities, and then also loss of essential services, which is sort of a catch-all. What we would do is add to this some issues that we hear frequently on our hotline, where people may not have a working refrigerator. They may not have working air conditioner, even though it was included in the lease that they would have that, which can be a serious issue for some people with various health issues. We would say that any loss of conditions or services or facilities that pose serious or negative impact on health or safety, that if there's been a notice for an intent to condemn for unsafe or unsanitary conditions, if there are non-working elevators, or if there are serious infestations, that these should also qualify as emergency issues. I'll again turn over to the both of you and see if you have any comments about habitability issues in general. I think Senator Dziedzic, you raised in your intro just how you had to deal with some of these issues particularly.
Yep, I've been dealing with them since I worked for Hennepin County. And recently, many of you maybe saw the Star Tribune did a story on the AG's office took a landlord to court, and because there were many unsanitary conditions in a lot of these apartments, and he was threatening a lot of the tenants to say, don't call the city, you can't call the city, I'm going to kick you out, call the city. And this goes back to what I was dealing with in 2010, where the tenant was afraid to call anybody because she was afraid of the landlord. She was afraid she couldn't find any other place to live. And so, what do these people do? And so I think this is an important one that, if you, and again, this is a small amount of landlords that do this, but they make the news, and this is what causes the problem. When we want everybody to live in a dignified area, and this is when you have young kids, a lot of these issues from heat to electricity to sewer sanitation, that is important, and that is a health issue. And so I think to me, this is just a basic, again, it's just housing is a basic need. And we need to have people living in dignified housing. If you are a landlord and agree to be a landlord, then you need to take care of that property, and you need to take care of the people that live there. And I don't think that's asking too much to repair the heat, repair the electricity. I understand that, things happen when, it might not be convenient for you. I know my heat went out. And I kind of joked that, great, it's going to be 20 below and I'm swamped and my heat's going to go out. And sure enough, it did, but I'm living by myself in a townhome. And so I, was able to say, no, I don't need emergency. Just put me on the list to come out. But, other people, again, with elderly or children living in the home, that is important. And so, I had one tenant call and say, well, the landlord said, she can't get to this for a few days. Well, when it's 20 below, you can't wait a few days, and from a perspective, the pipes could start freezing. And so you would think the landlord would want to take care of their asset. So, this isn't all landlords, but I think it is important that we put this in because you have a few bad apples that are not paying attention to their properties and to their tenants. And so, we need to deal with it. It's a safety issue. It is truly a safety issue.
I'll just add, and this is, you'd said there's some issues that need to be addressed right away, and that's no doubt. If the heat goes out, people need that taken care of right away. I just want to point out that last year, Representative Her asked that we work with Minnesota NARO because some issues may take a little while to repair, and there's a way to help compensate the tenants, or perhaps they need to be moved into a hotel for a few days while issues are being worked out. But we don't want to penalize landlords who are making every effort, but something is going to take more than a day to actually fix. So we negotiated with NARO, and I think have a very good understanding of that landlords immediately begin the process of repairing an issue. And if you're in greater Minnesota, there may not be as many people to help repair the issue that you need to have fixed. We want to make sure that we're fair to both tenants and landlords in this case, but tenants do need options while there's an emergency happening, and often that means that the landlord needs to compensate by finding them a place to stay while the issue is being addressed. Okay, and then let me move on to the next issue here. Court filing fees. Last issue here is that if a landlord fails to comply with the repair orders, tenants can file what's called a rent escrow in court for approximately $70 to enforce their rights. But if there's an emergency issue, like there's no heat, it actually costs $300 for emergency tenant remedies actions to be taken to court. We think it's absolutely ridiculous that if your issue is one that is an emergency, that it would cost more. And so Homeline's proposal is that filing an emergency tenant remedies action or a lockout petition would cost the same as a small court filing fee of somewhere between $70 and $80. It seems like this should be a non-divisive issue. I guess I ask again for what specifically on your thoughts on this, and then we'll turn it over for questions and answers from the audience. And again, you don't need to feel you need to add anything. I think, Eric, if you can come on in and help us get some questions from the audience, that'd be this is a great opportunity to do so.
Yeah, well, thank you to both of you and Michael for going through the agenda. And I want to just point out too, before we get to Q&A, which we have quite a few submitted in advance again, and some in the chat and the Q&A. So we'll get to those in a minute. Just that, this is this is Homeline's legislative agenda, and it's been picked up. Some of it has been picked up by Homes for All. There are obviously a number of other tenant landlord related policies that are important that we hear about on a regular basis, and provisions that were introduced last year and are proceeding. I mean, some examples are a more comprehensive reform of the actual court eviction process that I know Legal Aid has helped prepare. There was a policy introduced that would provide right to counsel in public housing eviction cases. And a number of other, there was a housing equity bill introduced that covered rent control, habitability issues, local crime-free ordinances, which is another issue that we care about a lot. And then I'll note just one more and give a little pitch that, as I know, I think Representative Her is an author of this bill, and apologies, I don't know everybody on the bill, but there's also the source of income protection. So creating a protection within the Department of Human Rights and the Minnesota Human Rights Act around the issue with tenants not being able to find a rental unit, being told no simply because they have a Section 8 voucher or some other kind of rental assistance. And I know there's an event that Minnesota Housing Partnership and Housing Justice Center are organizing this Friday, and I'll put some information in the chat about that because they're covering that bill. But for now, let's jump back and go to some of the questions that were submitted in advance that are specific to some of these policies. We got a question in advance about the pre-eviction notice. And the question is, will this proposal include a fund to pay the mortgages for landlords who must provide additional 14-day eviction notice? And if you don't, yeah, feel free to answer. Otherwise, I can comment, or maybe Rachel or Michael.
I guess we just see the issue differently here, is that an eviction is appearing on someone's record forever, unless it is expunged. And a 14-day notice, which, by the way, and I think Senator Dziedzic made reference to this, tenants, if they want an issue fixed that the landlord has broken the lease, they need to write a letter that provides 14 days for a fix to take place. And so this is a bit of parity on this, and saying that if a tenant has broken the lease by not paying rent, that 14 days are afforded to them, and hopefully also apply for assistance to make sure that they can help pay the rent and make both the tenant and landlord whole again.
Yeah, I think, a point was made about the timeline that, again, that happens with an eviction versus the timeline for foreclosure, and just the great difference there around the amount of notice and the timeline. So, okay, another question that came in. For legislators, do you think there is political will to pass tenant rights bills this session?
I would say that there's political will on the House side. We, I think, this is not a criticism of Minnesota. I mean, until very recently with Virginia, we were the only split legislature in the country. And that means that we all have to work really hard to compromise on bills that we put forward. And that means that, like, we sometimes have to send people like Michael back to rehab conversations with other people to include certain language. And so we always have a will to actually move it forward. And I am really hopeful that that we will at least get some things through, considering that I think we are maybe, even when we look at our pandemic situation and, as Senator Dziedzic said, not that the surplus, but, the projection looks pretty good, that, there are mechanisms in place to sort of support people, whether you're on the tenant or on the landlord side. And so my hope is that with all the different pieces in place, that we'll be able to get some of these legislation through. But I'm a very hopeful and optimistic person. So I don't know if that's necessarily what the will of the legislature will be.
I also am a very, eternal optimistic person. And so I always kind of, go forward and hope for the best, and focus on what we can get done and what we can, and how we can get there. And so I think there are pieces of this that I think everybody is agreeing that housing is critical. We have heard cities across the state tell us that the lack of affordable housing is costing them jobs, because the employers can't fill jobs because people don't have any place to live. And so I think housing is rising up there. I think some chambers are starting to realize that they need housing and you need affordable housing. So I think it is coming to the forefront. And so I am hoping with a combination of different pushes from different sides, from cities, from chambers, from actual people, that we might be able to come to some resolution and get some of these passed.
I want to add one thing. Political will is the political will of the bodies that you serve in, but the political will also comes from the people. And so here's your chance to tell over 100 people, what is it that we need to do to help you get these things through? And I want to ask that question of you, if you have any sense of sort of how to best use our resources to engage the legislature. But I also want to ask that if there are any organizations listening in on this today who would like to endorse the agenda that we've just put forward, to please let us know, because we want to show that there's a strong base of people who are very interested in these passing. But Senator Dziedzic, Representative Her, any sense on sort of how the public needs to weigh in on these issues?
I always tell people that come to visit me, and because I represent the University of Minnesota and Augsburg College, I get a lot of students that sometimes they didn't grow up in my district, but they now live there, so they come and see me, and I tell them they need to go back and talk to the people where they grew up. They need to go talk to those senators and tell them why this is important. And so I'm going to tell you all the same. You need to go and talk to your own senators and say why housing is important, why tenant protections are important, what we need to move forward to make the state better. And then I would specifically look at targeting some of the chairs. So in the Senate, we have Chair Nelson Carla Nelson is in charge of taxes. And I think that I think you will see, at least maybe from me, some proposals that are housing and tax related. And, Senator Dreiheim is truly passionate about housing, and he does want to reduce that disparity rates, and he does want to make some change. And so I would contact him. And then, President Miller is he's now President Osmek, but Majority Leader Miller is from Winona. And so he's another college town where, I know they have had housing issues, because I know people in my district from Southeast Minneapolis have worked with some in Winona to deal with housing issues. And so, contact him, and then contact President Osmek out there in the western suburbs. And he does listen to his constituents. And so if anybody lives out there and cares about housing, talk to him, because it is, like I said before, when we did the smoking ban, it was communities across the state that started moving this forward. And that was people pushing their communities to move things forward. And that's what we need now. We need people pushing electeds and pushing all of us to figure out how to help this housing crisis that we are in, that the pandemic just made worse.
And I would just add that because in the House, we are already supportive, and some of these bills we already passed through the Housing Committee, that I would actually focus your energy on the Senate side to sort of help move the needle there. And, so I think that Senator Dziedzic's recommendation is really good. And I would just say that too, in the most respectful way possible, because some of the pieces of legislation is actually very common sense. And so, and not just saying I really want you to support this bill, ask well, what is the pushback on understanding this? Because for them to be able to articulate why the bill is not getting heard or why it's not getting supported, so that, and not that for all of you to challenge them, but to say, well, I want to understand, because the more you sort of just ask in a way that asks to try to understand, the more it normalizes why this is so common sense. And it's not actually some huge revolutionary thing. It is, something that we should absolutely just be doing. And so I think the more that we can push that narrative, and the more that we can just, help understand their position, those in the Senate who have not been supporting it, I think the easier it'll be for us to move the issue forward. And Michael, I do just want to add one thing that I think that continues to help us be hopeful in this situation, is that I carried a bill last year for housing support, and it supports our elderly and disabled communities. And there were certain provisions in there that said, if they were out of their unit for a certain number of weeks, that they would lose that unit. And we increased that because we know that when people go in to work on issues of addiction, they may be out of their unit for 12 weeks. And so we were able to pass that, and we passed that at the 11th hour. It was actually not going to get included in the omnibus bill. And we were able to get agreement on that. And we were able to even increase the reimbursement amount a little bit on that. But those are the things that we should continue to have hope until the very last minute, because that bill was included literally at the 11th hour. And then I want to also state that prorated rents did pass, but that wasn't in this biennium. It was introduced the last biennium. So even when we think something is no longer viable, we have to always have hope to keep pushing it forward, because that did pass. And now landlords have to prorate rents. And so I think that those things for us to keep in mind as we continue to push this issue forward.
Thank you. Eric, keep us moving along.
Yeah, we've got 20 minutes and a lot of questions. So I'm going to jump to this one that was in the Q&A from Paul and just try to answer it really quickly. What are the 4 states without a pre-filing notice before a non-payment eviction is filed? So that was up on the slide. That's a complicated question and a good one for Paul to ask. There's not a quick and easy answer. We do have a memo that both us and Legal Aid have worked on. The short, easy answer is that for sure Minnesota and Maryland and West Virginia have nothing. There's then kind of a legal question as to what Missouri and New Jersey have. They have something that's questionable. So the answer is somewhere between 3 and 5, and those are the states: Minnesota, Maryland, West Virginia, and maybe Missouri and New Jersey. And so the quick answer is just that we are behind the times. We were behind almost all other states. So, okay, we got a question or maybe a comment from Scott here. The Attorney General's office provides standard rental contract in which anomalies from it can generate legal action by the Attorney General. This includes eviction notifications. So this is just one stipulation of this legislation, which is redundant to what already exists. Again, what third party legally reviewed this proposal, or do we have to ask our legislators to do the homework? And if either you want to answer it, or if Rachel, you want to jump in.
I can jump in at least about Minnesota doesn't have a standardized lease. There is no contract that the AG's office has put out. I'm aware of a suggested lease form that was put out by the Minnesota Bar Association several years ago, but there is no standardized lease in Minnesota. So I would love to see what is being referenced here, because if that's the case, then a lot of the non-payment evictions that we have seen through the years have been problematic for not having these notices.
I'll just add in that, and again, I'm not aware of any standardized lease that the AG's office has. I know there are other forms that I've actually forwarded on to people that are kind of model leases that a lot of people use. I have a landlord tenant handbook that the AG's office puts out that I have shared with many people. And we do our homework, and I do send most of my bills to people that I know agree with, and some that I think will have some concerns with the bill, because I do want to hear what they have to say. I do want to learn what is the pushback that I'm going to get to figure out, what do we need to do to this bill to actually make it work. And so I think most legislators do that. As Representative Her said, talk to the people to ask them why they don't like the bill and what is the pushback from the bill. Well, I send most of my bills out to other entities to ask them specifically, what's the pushback? What are your concerns about the bill? So, many of us do our homework. But again, I don't know if there's a standardized lease, and I'm talking to the Attorney General's office on a variety of rental issues recently, and this hasn't come up, but, I will ask again.
All right, thank you, Senator. Okay, there was a question that jumped through in the chat back when we were talking about the non-optional fees for non-optional services. Kate asked, does this bill, and thank you, Senator Dziedzic, I think put the language of the chat of the bill in the chat. But the question is, does this bill include an exemption of lawn and snow fees, lawn mowing and snow shoveling fees?
The legislation does not include anything regarding that. We're dealing with, and Eric, maybe you can answer that if there are additional fees of that note. I would think that again would be wrapped into the rent as sort of a regular cost of doing business. But if I'm not viewing this correctly, I'm certainly would be open to any help that needs to be provided. Yeah.
I have a thought on that as well. So snow removal and lawn care and things like that are part of the maintenance that a landlord is required, property owner is required to perform. And so charging a tenant for that service is potentially a violation of Minnesota statute that already exists anyway. If it's part of the rental cost, then it should be part of the rent, as you said, Michael. But the Minnesota statute 504B.161, in case anyone is a super statute nerd and wants to know, requires that if a landlord, the landlord reasonably maintains the property and complies with local ordinances and such, and that the only way that they can pass that along to the tenant is if they have some sort of conspicuous agreement with the tenant that states it, and that they compensate the tenant in some way, reasonably compensate the tenant in some way for that. So charging them a fee arguably for snow removal should then reduce the rent or something along those lines by that amount anyway. So long story short, a landlord shouldn't be charging separate fees for that service.
And again, this is often happening after application fees have been paid. And so these are expenses that are unknown and really should have been known in advance.
Yes. All right. Well, thanks for that answer. I'll just note, Paul, in the Q&A for folks who want to take a quick look, just mentioned another industry of housing that does do these types of fees, and that's in hotels. And so Paul says he agrees with the legislators that this is a basic consumer protection that should ring a bell, not just for low-income tenants, but for many people. Okay, we'll jump to another question from Scott here. Scott says, sounds like you'll be adding lots of additional security deposits amounts to tenants' rents to cover this additional eviction time and potential legal fees. Let the cities mandate their own laws. Additional constraints may be good for issues in Minneapolis and St. Paul, but the rest of the state can manage themselves without Big Brother. The private sector and relationships between landlords and tenants are much better managed by ourselves rather than bureaucratic intervention. And I open it to anybody. Rachel gets to answer.
Yeah, unless someone else has something first. Go ahead.
Well, I can add that, there is a senator that would ask me repeatedly, is this a Minneapolis issue or is this a statewide issue? And so I am usually prepared when I go ask him to hear a bill to show that this is a statewide issue. And I had the bill a few years back that many landlords in my area, again, I represent a lot of students, were requiring people, you didn't just move in and out on September 1st. They were kind of saying, okay, we want you, if you didn't renew the lease, we want you out August 12th. And then, oh yeah, you can't move into September 5th. And so they were stretching that out. They were doing bait and switch where they were showing you this unit, but when you go to rent the unit, when you go to move in, you're not getting the unit you saw. And so we actually kind of worked on that. And as we were presenting that bill on the floor, there were several other people not from Minneapolis and St. Paul that stood up and said, wait a minute, this is happening in my community. I just heard from some of my constituents that, they're running into the same thing. And so lots of times when people think that they're just Minneapolis, St. Paul issues, they're not always that way. And, again, as a Minneapolis senator who gets asked all the time, is this a Minneapolis issue or is this a statewide issue? I work on that and I do check that out. And again, that one bill shows when, we thought it was going to be a 10-minute floor discussion, super simple. And it was like 45 minutes because all these other senators were standing up and talking about how they're hearing the same things across the state. So, you just never know. So
I'll just note that Homeline has a hotline, and that hotline takes calls from across the state, probably close to a couple thousand each month right now. And again, I want to emphasize across the state. These are not just Minneapolis, St. Paul items, and We expect you to be calling upon folks in the community that are from different parts of the state to make the case that these issues are real and one that needs to be addressed on a consistent statewide basis.
All right. Thank you. I'm going to jump to another question here. Dave says, an increasing number of landlords and park owners are only allowing rent to be paid through automatic deduction or electronic transfer. This can be a problem for many people with limited incomes and poor credit. Are there any requirements that alternative methods of payment be offered? If not, are any proposals being made to require it? And that's not something that's in this legislation, but is, I think, something we also see at Homeline as well.
Thanks for raising the issue, Dave.
And Michael, I did just want to add that I think that Dave raises a really good point, because there are those who are unbanked. There's a huge population of our communities that are unbanked. And so this would be something that we could use to address some of that. So it'd be good for us to look into in the future, and appreciate him bringing it up.
About the bill, some of the bills. I think this first one is regarding the infirmity bill. Could you add hotel being provided in some of these instances for elderly and children? Oh no, sorry, this might be around the emergency tenant remedies action as an option. And then also she's mentioning that if you go to try to file an emergency tenant remedies action, you have to be there by 4 p.m. Yes, I mean that might be true in Hennepin County, where the time that the courts are open. Is there some sort of electronic option? And I think there may be, but that might be those are just a couple comments raised by Linda. Okay, I'll jump to this one. I think maybe Senator Dziedzic commented on Larry's question about the chances of progress in the Senate, but if you have anything else you want to add, Senator.
I'm just eternally optimistic, and we're just going to keep pushing and trying.
All right, thank you. So David asks, so I think this is, okay, this is regarding, David's question is regarding the 24-hour emergency tenant remedies action and the change to that, the proposed change to that. David says, I would hope there are some carve outs for the 24-hour notice rule for such reasons as flowing water, carbon monoxide alarms, electrical problems affecting more than one unit, and screams for help.
I do want to just state that, again, in the way the legislation is written now, that if there is an emergency, or that the landlord contacts you and says, I need to get in because water is overflowing, that the tenant can say, yes, you can come in right now. So it's already built into the current legislation right now.
And I think that's right. I might be wrong. Maybe David's question is about the privacy rule. I think that might be right. Yeah. Yes, that's correct. And Rachel, you have the answer to that, I think, right?
Oh, I mean, yeah, sorry, there was one below that I got distracted by because I was called out on it. But yeah, the emergency situation isn't going away. That's already in state law, and it's not being affected. So if there's an emergency like water flowing or screams for help, those sorts of things are still are covered and will remain covered.
Yeah, so that's Minnesota statute 504B 211, and so that there already is an exception for emergency situations. I'll put that in the chat. All right, we're just gonna take two more here. I think maybe are just comments about possible legislation, and then I know we have some other legal related questions, and our time is coming to an end, so we will let Representative Her and Senator Dziedzic head off. Just a quick couple comments from Duran here. Have you considered expanding eviction diversion programs, and then also right to counsel in eviction proceedings? Those two items as a response to evictions.
And Eric, you might be able to answer part of this better than or Rachel about the right to counsel issues. What was the first issue that they brought up?
Yeah, so eviction or diversion programs, you know, there's work being done on those, and you know, that's, I think, always a resource issue, is that
Community mediation services.
right,
Yep.
right. And then you know, I think one of the purposes of the pre-eviction notice is to try to prevent the eviction from being filed in the first place. And so a lot of times the eviction diversion programs you know, they only are happening after eviction has actually been filed. So, you know, both are needed to prevent an eviction from filing, and then to prevent, if an eviction does get filed, to prevent a negative outcome and homelessness. And then on right to counsel, again, there is a bill out there. I apologize, I don't remember who's on the author of the bill, but there's a bill. Senator Dziedzic is okay. You know, if you want to speak to it, I think the right to counsel in public housing cases, right? Yeah. So there are some efforts around right to counsel. Also, I'll note, in the city of Minneapolis, I'm going to forget when it happened. I think it was in November or December, but the city of Minneapolis enacted a right to counsel law. It needs to be, I think my understanding is it needs to be adequately funded to make it happen in the city of Minneapolis, but the policy is there. So some of those things are happening. Okay, this has gone very fast. We only have a few minutes left, so maybe offer a last couple parting thoughts to Senator Dziedzic and Representative Her, and Rachel, can you stick around to answer legal questions for a little bit? Okay.
I'm here.
So thank you, Senator Dziedzic and Representative Her. If there's anything else you want to add, we really appreciate your time being here.
Thank you all for having us. Please feel free to reach out to our office and continue to have this conversation with us.
I will echo what Representative Her said. Thank you again for letting us join you, and thank you for all the work that all of you are doing to help us get more housing across the state of Minnesota. And again, reach out. I'll put my contact information in the chat. Thank you. Have a good day.
The both of you are great champions, and I just want to make sure that everybody recognizes that. I would love it if the thanks would be typed into the notes to show how appreciative we are of the work that you've been doing with us for the past several years, and look forward to some successes coming forward in this next session. Take care, and we'll be talking soon.
Thank you very much. Appreciate it. I'm just going to throw up on the screen the our schedule going forward, but we will answer a few more questions. I know Linda asked about our hotline, and we're typing something back to that. We are experiencing unprecedented volume in the number of calls we're getting, especially just at the start of this year. And so please, if you're a renter and reaching out with a legal question, leave a message. It's critically important you leave a message, and you will get a call back, or you can go on our website and email an attorney. Do I have the, I'll put that slide up on the screen as Rachel's answering questions. I've totally lost where I'm at here. Okay. There was a question in the chat from another Rachel, clarification on a mask mandate applying to rental properties. So again, going back in the slides, that was Minneapolis, Golden Valley, and Hopkins have recently passed mask mandates. Does this apply for residents walking to and from their units, aka do hallways count as common areas?
First off, I want to say solidarity to the RACHAEL Rachel out there. But yes, common areas are going to be anywhere that's not your own home, essentially. So the Minneapolis and Golden Valley regulations are talking about just rental properties. Hopkins actually goes into much more specific detail about what they mean. So I can try and drop that language in the chat as well. But essentially, what Hopkins is saying is that on these spaces includes hallways, corridors, lobbies, restrooms, mail rooms, elevators, trash and recycling rooms, fitness rooms, recreation rooms, laundry rooms, and other space owned and used in common by the residents, employees, and tenants of the building. So again, that's specifically called out in Hopkins, and the other two are just listing as rental properties. So But I would say any place that you actually can encounter another person that's not in your household.
All right. Thanks, Rachel. And Paul in the Q&A pointed out, which I should have done this earlier, is that housing attorney Samuel Spade here at Homeline and Paul Bernberg, who's chatting with us here and is a former Homeline attorney, prepared an article about privacy, Minnesota's privacy law. And I'm going to put a link to that in the chat, and we'll include it in the materials afterwards because it's relevant and sort of points out the how important the privacy law has been, that it does prevent tenants from any sort of landlord violation of privacy, not just very serious ones. So here's a link to the privacy article. Okay. And I wanted to say too, on the mask mandate thing, Homeline is going to be posting an FAQ that gives an overview of mask mandate situation, as it's already increased from Minneapolis to a couple other cities, and that may continue. And so we'll have that up on our website in the next within the next week or so. Okay, I'm trying to see if we have any here. Okay, well, we'll jump back to some that were submitted in advance. Kate, who's a landlord, said, "What can an independent landlord do to recover lost income from a renter stopping payment during COVID?"
There's a lot of options for that, Kate. That is going to be very obviously your own individual circumstances are going to vary. But one of the things that you can do that's probably going to be the most helpful is to honestly help your tenant actually like apply for something like rent help. If they're behind on rent, help them apply. Like, print off an application and like go to the door and be like, hey, do you need help with this? Figure out like if it's a technology issue, a language barrier, scared, just don't know about the program. Like, I know people think that there's no way that no one knows about rent help, but we get calls every day still of people like, oh, what's rent help? I've not heard of that before. So there are still people who just don't know what's out there. And so communication is so key. And we know that in a lot of situations that especially when at this point in a pandemic going on almost 2 years now, like a lot of communication routes have broken down, but I still think that that's possibly the best way to get for a landlord to actually get money. Because even if you say like went to conciliation court and tried to sue for it, as if the money's not there, the money's not there. And so the money is there with these federal programs. So that would be my suggestion. But again, your individual circumstances are going to vary as to how accessible that is going to be.
All right. Thanks, Rachel. And there's a couple other rent help MN related questions. A tenant asking about that they got rent help a couple weeks ago, and after their landlord got paid, the landlord called and emailed and texted with a balance due. And so, we don't have general advice on that. As individual advice, give us a call. As a tenant, please call our hotline. Again, the contact information is up there, but the general advice is, when the landlord is accepting the rent, it's for a specified number of months. So, there should be some clarity about that in the Rent Help Amend portal about what rent was covered. And then, the tenant can always go ahead and reapply if it is clear that there's an overdue balance. And going forward, of course, as Rachel mentioned, the new Rent Help Amend changes that you can apply for rent arrears, but it's only 1 month future rent that you can apply for. Okay. Another tenant asked about that they missed a court hearing for an eviction. Is there, and they believe they have reason to believe that they could file a quash or appeal and be able to stay or find a new place to live. Is that something you can comment on, Rachel, or is this another call the hotline?
So I will say definitely call the hotline, but in general, if you are going to try and file a quash or appeal a decision, you have a very short amount of time to do that, and frankly, they're very difficult to have happen. So it's usually best if you can get some legal advice to do so beforehand. So depending on how long ago the court date was and things like that, it might be feasible, it might not. But yeah, just keep in mind that an appeal, you get 15 days. A quash is just basically, you got to do it as quick as possible.
All right, and then a question from Sylvia about rent help MN. If a tenant receives Section 8 assistance, is the tenant also eligible for rent help MN?
Yes, for the portion that they are liable for. So not for the portion that Section 8 covers, but if whatever their portion is, if they're not able to pay that, then they can apply to rent help MN to help with that portion.
All right, and I again put a link in the chat for rent help MN. 211 is the place that tenants should call about questions like that and application questions. And then there's also a landlord email address that I put in the chat if landlords have questions about it. I'm not sure what this question is. We'll skip that. So maybe we'll get close to ending on this one. Karen asks, is it true that a tenant can change their lock if they then put the original lock back on the unit when they move?
Oh, well, that sounds like a very specific situation. But in general, we never recommend to tenants that they change their locks. It's always better to have the landlord do that if the situation requires it. In the situations where, like, if a tenant has already done that before they call us and things like that, we tell them they have to get their landlord a copy of the key ASAP, but it's not a good idea. It might be an evictable, I guess, offense for altering the property, essentially. So it's not, if you're a tenant, don't change your own locks.
Right. I'll just note that there's a number of comments from Scott and some feedback in the Q&A. I'm not sure if there was any questions remaining there, but folks can take a look. And we did get a couple of comments. For example, this anonymous one, somebody that works on housing services in St. Peter, Mankato area. And they said the bills and issues that were talked about are relevant to that area, often more acute because large property management companies that have monopolies, and folks work for those companies around. So thankful for this, as well as another comment from Sherry saying in Northwest Minnesota, they have some of these same issues. We're happy to come out and speak to groups. I put Michael's information in the chat, but we'll include that in the follow-up materials. And of course, we will post a recording and the slides and other materials from today on our website and send it out to attendees. So I don't know, I've lost track of all the chats and questions. So hopefully we got most of them. Thank you, Rachel, for fielding these questions, and Michael for introducing the legislators and the policies and emceeing that conversation. And unless there's anything else, we'll call the day. Again, Wednesday, February 2nd is our next session. Max Tsai and Shana Tomenes from Housing Justice Center, who are currently Rent Help MN field partners, are going to be chatting about the whole process, Rent Help MN navigation of applications and issues related to that. So tune in then. Otherwise, thanks everybody, and we'll see you later.
Thank you, Eric.